Hello and welcome back. Today we're going to finish our discussion regarding torts. Last week we talked about intentional torts and we covered quite a few of them. This week we're going to talk about unintentional torts, which is described as negligence. Negligence takes place when one has a duty to act reasonably, but instead acts carelessly and causes injury to another person. There are 4 elements to prove negligence. Now, I know in your textbook there's an indication that 5 are present, but I'm going to include just 4 because cause contains 2 other aspects which will be discussed in a little while, that being the actual cause and the proximate cause. But these are the 4 general elements that common law tort claims involve. First, there must be a duty of care, a recognition by the court that a standard of care, a duty, is present. Secondly, if there is a duty that is present, has that duty been breached? If so, has the breach caused the injury or the damage to the plaintiff? And of course, the plaintiff is the person who is seeking recovery from the defendant's actions, in other words, the defendant's negligence. Because inaction can also be a form of conduct that can lead to a claim of negligence. As your textbook authors indicate, the critical element of negligence is the duty of care. The duty of care. And think of duty in the sense that there is an obligation. An obligation. You're obligated to do something. And the obligation is to make sure that your actions or your inactions do not cause harm to someone else. The basic concept underlying the duty of care is that people are free, in other words, they have a right to do as they choose as long as their actions do not injure another person. So we have this balance between rights and duties with respect to tort law. And the defendant, again, would be the so-called tortfeasor. A person doing something has a legal duty, or think of it as an obligation, to act reasonably to avoid injuring others or interfering with others' rights. Tort law determines duty by the reasonable person standard. And we've talked about that standard previously. That standard is used in contract law and it's used again in tort law. Courts ask how a reasonable person would have acted in the same circumstances, in the same situation. It is an objective, not a subjective standard. And again, last week we talked about the reasonable person standard being the objective third-party standard as opposed to the internal or subjective standard by which liability is measured. And in this context, we're focusing on, is there a duty owed? Is the duty owed viewed from a reasonable person perspective? Yes, not from some internal subjective perception. Now, special relationships may also enhance the duty of care requirement. And let's talk about that for just a short while. There may be a duty to warn business invitees of risks. In your textbook, and I hope you've read this chapter thoroughly because there's a lot of information in this chapter, there's also a case. There's a case called Inanelli versus Burger King Corporation. Let's see if it's on the next slide here. Yes, it is. It's In your textbook on either page 294 or 304, depending upon your edition of the textbook, make sure you read this case and understand it, because it involves allegations of negligence, but also where there's a duty and a reasonable person standard that's applied. And at the end of this case, as is the standard here that your textbook authors use, there's always follow-up points or follow-up questions that are raised. And in these key points following the case, there's a notation that a restaurant has a duty of reasonable care to those who are eating in the restaurant, yes, but protecting them from assault does not normally fall within the duty owed to diners at a restaurant. That's just something that wouldn't be foreseeable unless circumstances exist. Now, in this case, having read the facts, there were circumstances that exist to put the company, that is Burger King, on notice that there is a propensity or a likelihood that an assault or some type of skirmish could have occurred. As your authors note, when warning signs indicate that individuals eating in the restaurant may not be safe, the manager of the restaurant has a duty or an obligation to take action to try to prevent injury. Warning signs in this case included the obnoxious behavior by the teenagers and one of them bumping into a child yet expressing indifference to the encounter. The court found that a duty to protect diners from assault might exist if the restaurant employees become aware of the danger and did not take or do not take basic measures to prevent it. So make sure you read that case carefully. It involves a business setting, and certainly our whole study this semester has involved the legal and the regulatory environment of business. Tort law regulates business conduct, business planning, and certainly the operation of businesses generally with respect to the assessment of risks and liabilities. Let's talk also about the duty of professionals, and there's an enhanced standard of care beyond reasonable care when professionals are involved. In your textbook, there's a provision that the duty to act reasonably also applies to professionals like doctors, lawyers, CPAs, architects, engineers, and others. In most negligence cases, however, the standard of reasonableness is that of a reasonable person. Now, when a professional is involved, there's an enhanced standard of care. When the negligence allegations are made against professionals, the standard is that of what a reasonable professional in that setting would have owed in terms of a duty. And that negligence of professionals is called malpractice. Let's talk further about the breach of duty. A jury can determine the issue of breach, but it is often one that involves a question both of law and fact. Now, we know what fact is, right? Fact would be the circumstances, the occurrence, what happened. And the jury often decides questions of fact. We've talked about that many times in this course already. The law is comprised of rules, and in common law, those rules come from cases. When we apply statutory law, the law in the form of rules arise from the legislative acts, the legislative statutes. A judge can determine as a matter of law whether a duty exists. That is usually within the province of the court. And when so, then the jury will determine whether that duty was breached by applying the standard of reasonable care. A business owner may have a duty, for example, to discover and remove hidden dangers that might injure a customer or other invitee. And just some examples would include hidden dangers such as uneven surfaces, maybe defects in the pavement of a parking lot or a walkway, or even items that have fallen off the shelves in a store. Many years ago, when I was a much younger lawyer, I had a case where I was representing the plaintiff, and the plaintiff was walking in an aisle in a grocery store where items had fallen off, vegetable items had fallen off on the floor, fallen off to the floor. And my client, the plaintiff, was unaware that certain vegetable items, in the vegetable aisle had fallen off because people, obviously, before she was present, maybe could have knocked off a vegetable item, or something could have occurred where a vegetable would have fallen on the floor. But in this instance, she was walking in the aisle in the vegetable area where it was, refrigerated. I think you can imagine, the setting. And without any warning or notice, she slips and falls on a vegetable item that's on the store floor. Now, the question is there a breach of duty? Well, the grocery store has a duty to its invitees to make sure that its premises are safe, that it's a safe place for its customers to walk. And was, however, she on notice based on her past visits to that store, that at times there might be items that fall from the shelves that land on the floor, and maybe the argument for the defense is that she should have been aware of that fact from previous history and should have been more careful in where she was walking. But that's a question of, one, is there a duty? Two, whether that duty has been breached. Three, what is the cause of the damages that resulted? And is the cause not only the actual cause or the proximate cause? So, just by way of an example, in the context of breach of duty. If a person breaches a duty of care and injury results to the plaintiff, because the person would be the defendant or the tortfeasor, what caused the injury and the breach must be closely examined. Courts will ask two questions. The questions are, one, was there a causation in fact? And question two, if so, what is the proximate cause? What is the proximate cause of the injury that resulted from the breach of the duty? A plaintiff must prove that the defendant actually caused the injury. Courts leave questions of proximate cause and causation in fact to the juries to decide, as long as evidence reveals that a defendant's alleged carelessness could have been a substantial material factor in bringing about the injury. Causation, in fact, is therefore determined by the use of a so-called but-for test. But for the defendant's negligence, would the injury have resulted? Now, if we look at the example, or consider the example I gave just a few moments ago about my client that fell in a grocery store, in the food aisle, in the vegetable aisle, where she slipped on a vegetable item. Well, is the vegetable item on the floor the real cause of her slip and fall? Well, I suppose that would be a question of fact. Is that the reason she fell? Is the vegetable item on the floor the cause of her injury? That may be the actual aspect. However, is the fact of the injury and the cause related to the defendant's negligence? but for arguably the grocery store's observation or their care in making sure that vegetables are not on the floor, would the injury have resulted? Those are questions that we're going to be discussing in terms of causation and fact, using the but-for test and proximate cause. Another term for proximate cause is the legal cause. It exists when there is a connection between an act and an injury that warrants a finding of liability. And of course, we know what the term liability means. It's liability, meaning legal responsibility or legal fault. Let's talk about proximate cause. The concept of foreseeability. Foreseeability. Think about that word. Is inherent in determining whether proximate cause exists. Foreseeability means that the plaintiff must have been one whom the defendant could reasonably expect to be injured by a negligent act. Would the grocery store foresee that if a vegetable item was on the floor, that a customer could, walking by the shelf, slip and fall on that item? Was that reasonably foreseeable? Probably the most frequently cited case for establishing the concept of foreseeability and proximate cause is the Palsgraf case. This is a very old case. It is still good law. In fact, its effect on the law in tort law is profound. Please look on page 299 or 309 in your textbook. It's under sidebar 10.8 regarding the Palsgraf case. I want you to make sure you've got a good understanding of the facts and the outcome in Palsgraf. Because of the Palsgraf case, liability will not be imposed on the defendant unless the defendant's actions created a foreseeable risk of injury to the plaintiff. I want to go over the facts in Palsgraf in just a little bit of detail to give you some further points here of understanding and reflection. Helen Palsgraf was waiting for a train on a station platform. A man carrying a package was rushing to catch a train that was moving from a platform across the tracks from where she was standing. As the man attempted to jump aboard the moving train, apparently he seemed unsteady and was probably going to fall. A railroad guard or an attendant on the train car reached forward to grab him, and another guard or attendant on the platform pushed him from behind to help him board the train. Now, in the process, the man's package, which, unknown to the railroad guards or attendants, contained fireworks, and the package fell on the railroad tracks and exploded. There was nothing about the package to warn or give indication about its contents. There was no warning or notice that it was explosive in content. The repercussions of the explosion caused big scales at the other end of the train platform to fall on Ms. Palsgraf, causing her injury, and because of her injuries, she then later sued the railroad company. At the trial, a jury found that the railroad guards or attendants had been negligent in their conduct. The railroad company appealed, and New York's highest state court ruled that the railroad company was not liable to Palsgraf. The railroad company had not been negligent towards her because her injury was not foreseeable. Now, think of the situation if the box or item that the passenger was carrying had been clearly marked as containing explosives. In that situation, there would have been some notice that care would be needed so as to prevent that package or that box from falling to the ground. But in this case, there was no indication whatsoever that that box contained explosive items, and hence there was no possible way that the railroad, by its attendants or by its guards, could have reasonably known in advance that their conduct would have resulted in possible negligence and injury to Ms. Palsgraf. So again, that information is in your textbook, and we'll talk about more of proximate cause and some other examples when we have our discussion this upcoming Wednesday. Last, let's talk about the fourth element, which is injury or damage. To recover damages, the plaintiff must have suffered loss, some harm, some wrong, or some invasion of a protected interest. If no harm results, even when there has been a duty breached, there's no obligation to pay or to compensate. So in other words, there could be a duty that's imposed and a breach of that duty that related to a matter that caused an issue. But if that issue resulted in no harm whatsoever, even if the duty was breached, there's no obligation. So harm must be established. There has to be some measure of loss. I hope that's clear. So let's talk about damages for tort claims. We've already talked about these damages before. There are two: compensatory damages and punitive damages. Compensatory damages, as you well know, are designed to compensate for the injuries caused. That may include distress, pain and suffering, anguish. Lots of different factors may be considered in compensatory damages to award a plaintiff who suffered a tort-based injury. Punitive damages we've also discussed. They are not to compensate, but to punish. Punitive damages are going to be available when the conduct is so egregious, so willful, so wanton, and by the way, those are terms that are found in your textbook as well, that the law allows for damages to be imposed to punish and, by example, to deter others from exhibiting the same type of behavior or conduct. So punitive damages are designed to punish and to deter, by example, that type of behavior or conduct from occurring again. Compensatory damages are designed to compensate. So note the difference, and hopefully there's no misunderstanding of these two terms. Now, simply because there have been allegations of negligence does not mean that liability automatically will be imposed. There are defenses, and I don't want there to be any confusion here, because I often find that students will recognize that when there have been the four elements established, there will be automatic liability imposed. Not so. The defendant may raise legal defenses. There's always going to be possible legal defenses to claims. And in the area of tort law, negligence, these are the three primary defenses: assumption of risk, contributory negligence, and comparative negligence. A plaintiff who voluntarily enters into a situation that involves risk will not be allowed to recover damages. The defense of assumption of risk requires two elements. One, knowledge of the risk, and 2, despite that knowledge that the risk was present, a voluntary assumption of that risk. Assumption of risk may be implied under the circumstances, or it can arise from an expressed agreement. Many businesses will attempt to relieve themselves of potential liability by having customers agree contractually not to sue for negligence. In other words, they are seeking the employee, for example, or the customer or the invitee, for example, to assume the risk by contract and to exculpate the defendant from liability. These are exculpation clauses in contracts. Many of these types of contracts may be unenforceable based on public policy. And having already talked about, studied contract law in this course, that's the fifth element of contracts, right? We know that the contract must be containing a legal objective. Courts will determine whether that legal objective is present, and if not, whether there is a public policy that may strike or avoid the contract from being enforced. Let's talk about contributory negligence. A contributory negligence defense bars the plaintiff from recovery if the plaintiff's own fault contributed to the injury to whatever extent. In other words, under the common law doctrine of contributory negligence, a plaintiff who is also negligent to whatever degree, to whatever extent, cannot recover anything from the defendant. No matter how insignificant the plaintiff's negligence was by comparison to the defendant's negligence, a plaintiff would be prevented from recovering any damages. Now, historically, the contributory negligence defense was the main defense to negligence. And the rationale was that if a plaintiff was negligent, to whatever extent, they should not seek, by way of the court's justice, also to be compensated from a defendant that was negligent as well. So the contributory negligence defense was a bar against a recovery. Let me give you some context to maybe explain how this defense will be raised in terms of a jury trial. The jury is going to be asked by way of instructions, and you know what that is because we've talked about jury instructions in the course, whether there is a finding that the plaintiff was also negligent. So let's assume, for example, that the jury decides that the plaintiff is going to be entitled to $100,000 as damages as a result of the defendant's negligence. Then the question is asked by way of a jury instruction whether the jury determined from the facts in the case at trial whether the plaintiff was also negligent, and if so, to specify what percentage, in the jury's opinion, the plaintiff's negligence constituted in terms of their own harm. So if a plaintiff was 5% negligent in contributing to his or her own injuries, and the defendant was 95% responsible for the plaintiff's injuries, then what would be the end result of the plaintiff's recovery? Zero. The contributory negligence defense bars the plaintiff from recovery if the plaintiff's own fault, as decided by the jury, contributed to the injury to whatever extent. Now, many jurisdictions have adopted a comparative negligence defense. I'm going to go to the next slide first. Due to the harsh rule of contributory negligence, under the doctrine of comparative negligence, there is a different result. So, through policy developed by the legislature there is a comparative negligence defense. Under the comparative negligence defense theories, the plaintiff's contributory negligence does not bar recovery. Instead, the comparative negligence defense apportions or compares the plaintiff's fault with the defendant's and reduces the damage award proportionally. Many jurisdictions have adopted a pure form of comparative negligence that allows the plaintiff to recover even if his or her fault was greater than the fault of the defendant. Many states, however, utilize a so-called 50% rule. Under this rule, if the plaintiff was more than 50% negligent, there is no recovery available. For example, a plaintiff who was 45% at fault can recover 55% of damages. If the plaintiff was 55% at fault, there is no recovery. So let me go back to that example earlier. After the evidence has been submitted to the jury, the judge reads the jury instructions to the jury convenes, and they decide that based on all of the evidence, applying the law, applying the four elements of the law, duty, breach, cause, damage, that the defendant was negligent in causing the plaintiff's injuries. And they arrive at the sum of $100,000 as a verdict. Now, under this example, a plaintiff who is 45% at fault can recover how much in terms of that $100,000? 55%. $55,000. However, under the 50% rule, if the plaintiff was 55% at fault, there's no recovery. No recovery at all. Under the traditional comparative negligence defense, if the plaintiff was 55% at fault, instead of no recovery, what would be the amount of the recovery? $45,000. Hopefully that's clear. It is confusing, nonetheless, I know, but these types of defenses need to be understood by way of your study in the tort law chapters. Why is this important in the context of the legal and regulatory environment of business? Well, do you think businesses need to deal with allegations of negligence and fault and risk and damage? The answer is clearly yes. Yes. And certainly risk assessment and a good understanding of what tort law allows for will probably promote a better management and a better understanding of whether there are duties and what the best course of action is to create a safe workplace, a safe business for invitees and employees and anyone else that's going to be in contact with that organization. So all of this, of course, is found in your textbook. We'll spend more time on Wednesday discussing any questions that you may have, but do read these sections very closely, very carefully, particularly the cases that I pointed out today. Again, if you have questions, please feel free to contact me. Thank you for your time, your interest, and your continued participation.